Hello students, today we are going to discuss the topic feasibility of the Uniform Civil Code in India. To start with the introduction, the Uniform Civil Code debate in India began during the drafting of the Constitution and has been ongoing since. The recent ruling in the case of Sharana Bano, where triple talaq was found unconstitutional, has brought the matter to the forefront of public debate. The notion of Uniform Civil Code would replace personal laws that are based on religions, customs and traditions with one common law that would apply to everyone regardless of their religion, caste, creed, sexual orientation or gender. This would be done in an effort to standardize the legal system. Students, the origin of the Uniform Civil Code can be traced back to a report that the British government issued on colonial India in the year 1835. In this report, the British government emphasized the need for uniformity in the codification of Indian law with regard to crimes, evidence and contracts. Additionally, the report specifically suggested that the personal laws of Hindus and Muslims be kept outside of such codification. The Constitution of India in its fourth part includes a provision that says the state shall endeavour to secure for all citizens a uniform civil code throughout the territory of India. This provision refers to the Uniform Civil Code. Regarding issues such as marriage, divorce, inheritance and adoption, the founders of our nation envisioned that there would be one day be a standardized body of legislation that would take the place of the archaic personal laws that were practiced by each religion. The UCC is included in the directive principles of the state policy, which are fundamental to the administration of the country but cannot be enforced or defended in a legal proceeding because they are not justifiable. Now, let us discuss the evolution of the concept. Students, the efforts at codification that were seen throughout the 19th and early 20th centuries in a variety of European nations served an inspiration for the formulation of Uniform Commercial Code. Due to its comprehensive elimination of customary and statutory laws that were prevalent during that era, the French Code of 1804 exerted a significant influence on the development of UCC. This was accomplished by establishing a standardized code which led to the codification of UCC. At a more fundamental level, it constituted an effort to cultivate the nation as an integral part of a larger colonial undertaking modelled after that which was undertaken by Western powers. This was an aspect of colonial enterprise. In spite of this, the first war of Indian independence, which took place in 1857, was successful in sending a message to the British colonial rulers. This message emphasized the significance of maintaining the social structure of India and upholding the established norms governing the various aspects of marital relationships, divorce, financial support, adoption and inheritance. Students, under the recommendation of the committee, which was founded on the teachings of the scriptures, a codified version of Hindu law would grant women the same legal rights as men. Following a review of 1937 Act, the committee proposed the creation of a civil code that would govern Hindu marriage and succession. The Constitution's drafting committee stages began with the subcommittees on fundamental rights, constituted to compile a list of fundamental rights that could be added to the Constitution. The subcommittee mulled the possibility of dividing fundamental rights into justifiable and non-justifiable rights, with the former being enforceable by courts and latter not. The subcommittee presented its report to the advisory committee, which included a list of fundamental rights divided in two parts. The majority of the subcommittee members believed the Uniform Civil Code should be incorporated as a non-justiciable right. However, some members, including M.R. Masani, Hansa Mehta and Amrit Kaur, argued that the Uniform Civil Code should be included in the part of fundamental rights that can be litigated. This dissent note demands that the UCC be included in the part of fundamental rights that can be litigated, addressing the divide between the Indian people and their religious beliefs. Students, in 1948, Ambedkar presented to the Constituent Assembly for discussion the draft constitution, which included provisions regarding the Uniform Civil Code. The Muslim members of the assembly proposed amendments to introduce provisions to the draft Article 35, ensuring that personal laws would remain outside of its scope and the Uniform Civil Code would only be implemented with the prior approval of the community in question. Muslim members Ismail Sahab, Naziruddin Ahmad and Pokkar Sahib Bahadur opposed the Uniform Civil Code, arguing that it violated the freedom of religion, would disrupt harmony within the Muslim community, and required the approval of various religious communities prior to any changes. Students, K.M. Munshi, Aladi Krishna Swamy and Ambedkar defended the Uniform Civil Code, arguing that it was important for nation unity and upholding the secular credentials of the Indian Constitution. The government had no choice but to establish B.N. Rao Committee in 1941 in order to codify Hindu law as a result of increase in legislation addressing personal concerns following the end of British rule. The Hindu Law Committee was responsible for investigating whether or not common Hindu laws are necessary. The Constituent Assembly approved draft Article 35, which was subsequently renumbered as Article 44 of the Indian Constitution. The decision to include the Uniform Civil Code in the directive principles as opposed to fundamental rights was viewed as a compromise between supporters and opponents, allowing future legislatures to make final decisions. Students, the personal laws of Hinduism are thought to have originated from ancient religious texts and practices. Marriage and divorce are regulated by Hindu Marriage Act of 1955, while the Hindu Succession Act of 1956 addresses issues related to inheritance. Both laws were passed in 1955. In accordance with the Hindu Succession Act of 1956, which was passed in order to regulate the rights of Hindus, Buddhists, Jain and Sikhs, Hindu women have the same rights as the Hindu men to inherit property from their parents and are entitled to same amount of inheritance. Now coming to Muslim personal law, the Sharia serves as the foundation of what is known as Muslim personal law, which is followed by Muslims in India. Marriage, divorce, inheritance and support obligations are some of the areas of Muslim life that are regulated by Muslim Personal Law Shariat Application Act of 1937. The Indian Succession Act of 1925 governs the succession of Indians who identify as Christian, Parsi or Jewish. Christian women are allotted a certain portion of inheritance based on the number of children and other relatives in their households. Students, widows in the Parsi religion are given the same inheritance as their children, with the proviso that if the deceased person's parents are still alive, they are entitled to half of the child's share. After India attained independence from British rule, it was not a good option to remove personal laws from the sphere of interpretation, leading to the adaptation of UCC as a directive principles as discussed above. Students, partition was a factor in both of these outcomes. Despite the fact that the authors of the constitution attempted to introduce a Hindu code bill in the parliament that would have included progressive measures such as giving women equal rights to the inheritance, the bill was ultimately unsuccessful and never saw the light of the day. The discriminatory provisions in the Hindu Succession Act 1956 were removed with the Hindu Succession Amendment Act 2005 receiving assent from the President of India. Now, let us discuss judicial interpretations of the issue. In this light, from a judicial point of view, the Supreme Court has emphasized the importance of having a UCC in several cases that need to be analyzed, starting from the Shah Bano Begum case of 1985 to the recent Shaira Bano versus Union of India of 2016 case that questioned the legitimacy of the practice of talaq-e-biddat, that is triple talaq, and declared it unconstitutional. After Shah Bano's husband pronounced talaq against her, the Supreme Court began hearing cases involving the issue of maintenance in accordance with Section 125 of the Code of Criminal Procedure. The first of these cases involved Muhammad Ahmad Khan versus Shah Bano Begum and others. In the course of rendering his decision on the matter, Chief Justice Y.V. Chandrachud made the observation that the Parliament ought to sketch out the general outlines of a common civil code because such a code is an instrument that promotes national harmony and equality before law. Despite this, in 1986, the government passed Muslim Women's Protection of Rights on Divorce Act in order to ensure that Muslim women would be protected in the event of a divorce. The constitutional validity of this act was upheld in Daniel Latifi versus Union of India 2001. Students, in the light of the Supreme Court's ruling in Noor Sabha Khatun versus Muhammad Qasim 1997, it is evident that Section 125 of the Criminal Procedure Code supersedes Section 31B of the Muslim Women Protection of Rights on Divorce Act 1986. Section 31B of the Act stipulates that a divorced wife may only claim maintenance for children living with her for a period of 2 years from the Supreme Court's notice to consider the validity of a triple talaq pronounced by Muslim husband against his wife. The Supreme Court rejected the Patna High Court's ruling and ruled that a divorced mother's right to seek child support is unrestricted. The obligation of the father to pay maintenance to children residing with the divorced wife is absolute under both Islamic personal law and Section 125 of the Code of Criminal Procedure. Students, a divorced Muslim woman is entitled to maintenance for her children until they reach the age of majority or until they can support themselves. It's important to note that the Sharia law, that is Muslim law in its entirety, does not govern Muslim related matters in India in their entirety. This is due to the fact that it applies only to Muslim family matters and has been modified or restricted by other laws with uniform application. These include but are not limited to the Waqf Validating Act of 1913, the Shariat Act of 1937, the dissolution of Muslim Marriage Act of 1939, the Indian Contract Act of 1872, the Indian Evidence Act of 1872, the Indian Penal Code of 1860 and the Code of Civil Procedure. In the light of constitutional provisions and Quranic text, the Supreme Court limited the application of Muslim law, particularly with regard to triple talaq, that is talaq-e-biddat. This occurred in the case of Shaira Bano versus Union of India in 2016. A number of writ petitions, including the present case, have been filed under the Shariat Act of 1937, which allows for a valid divorce. A constitutional bench of the Supreme Court decided the case with a 3-2 majority after examining various Quranic verses, Muslim laws in other Islamic countries, pertinent constitutional provisions, opinions of the Muslim scholars, and obviously the arguments from both the sides. The court ruled that triple talaq is arbitrary because it precludes any possibility of reconciliation between the parties in an effort to save the marriage. It is declared arbitrarily and capriciously. Consequently, it violates Article 14 of the Constitution. The court also ruled that Section 2 of the Act of 1937 is invalid to the extent that it permits triple talaq. Despite the fact that this case is not directly related to the concept of a uniform civil code, it is clear from this ruling that any law of any community must be in accordance with the constitutional provisions and rules of natural justice in order to adapt to the changing social structure of the country. In the case of Pragati Varghese versus Cyril George Varghese 1997, the Bombay High Court invalidated Section 10 of Indian Divorce Act of 1869. When a Christian wife seeks a divorce on the basis of cruelty or desertion, this section stipulates that she must also prove adultery. The full bench of the Bombay High Court ruled that the Section 10 of Indian Divorce Act of 1869 is unconstitutional because it violates a Christian woman's right to live with human dignity under Article 21 of the Constitution. The court noted that Section 10 of the Act requires the wife to live with the man who has deserted or mistreated her. There is a refusal to dissolve the marriage when the marriage has irretrievably broken down. In the case of John Valamattam and another versus Union of India, the Supreme Court reaffirmed its support for the implementation of a uniform civil code. The decision was rendered by a 3-judge bench. The petitioner challenged the constitutionality of Section 118 of Indian Succession Act of 1925 on the grounds that it was discriminatory under Article 14 and violated Articles 25 and 26 of the Constitution. The power of a Christian to bequeath his property for religious or charitable purposes is addressed in the Section 118 of the Act. This section restricts a Christian's ability to make a bequest if he has a nephew, niece or other relative. The term relative includes an adopted son but excludes the testator's spouse. The court ruled that the Succession Act Section 118 is unconstitutional because it violates Article 14 of the Constitution. Further, the court ruled that Article 25 and 26 do not apply in this case because the disposition of property for religious and charitable purposes is not an integral part of the Christian faith. These articles only protect rituals and ceremonies that are fundamental to religion. Students, in the case of Seema versus Ashwani Kumar 2006, A division bench of the Supreme Court comprised of the Honorable Justice Arijit Pasyat and Mr. S.H. Kapadia issued a landmark decision on the issue of the consequences of non-registration of marriage. The court ruled that all marriages must be registered regardless of the religion of the parties. Within 3 months, the court ordered the central and state governments to amend the law, create rules and notify the public. After soliciting feedback from the public and analyzing it, the rules could be formalized. The court also noted that these rules would remain in effect until the respective governments enacted legislation mandating the registration of marriages. Moving on, in the case of Sarla Mudgal versus Union of India and others 1995, the Honorable Supreme Court commended the government for securing a uniform civil code. Both the Lily Thomas versus Union of India and the ABC versus State, that is NCT of Delhi, cases were resolved in a manner analogous to this one. In the first instance, Supreme Court underscored the importance of uniform civil code with regards to the inheritance matters. Conversely, in the second instance, the court determined that a mother who practices Christianity could seek the sole guardianship of her child without the consent of the biological father as per Guardian and Wards Act of 1890. It is noteworthy that this act did not previously acknowledge the rights of unmarried Christian mothers. In aforementioned instance, the Supreme Court underscored the importance of uniform civil code with regards to the matter of inheritance. Within this specific context, the court placed significant emphasis on the adverse consequences that arise due to the absence of a universally standardized civil code. In the years that followed, various interventions by the judicial branch and organizations representing civil society worked towards the goal of amending personal laws or establishing a uniform civil code. The notable judgments of Muhammad Ahmad Khan versus Shah Bano Begum, Jordan Deengeh versus S.S. Chopra and Sarla Mudgal versus Union of India all contribute to this conversation in their own unique ways. In the case of Shah Bano, the court made the observation that Article 44 has remained a dead letter. They also stated that a common civil code will help the cause of national integration by removing desperate loyalties to laws that have conflicting ideologies. It was stated that the duty of securing a uniform civil code for the citizens of the country is to be entrusted with the legislative branch of the government. In order for the constitution to have any significance at all, we need to get the things started. In the case of Sarla Mudgal, which took place in 1995, the Supreme Court requested that the Prime Minister re-examine Article 44 with the intention of establishing UCC across the entirety of India. On the other hand, subsequent orders in Ahmedabad Women Action Group case 1997 and the Lily Thomas case 2000 made it abundantly clear the court did not direct the government to enact a UCC in the Sarla Mudgal case. Now let us have some observations on the use of Uniform Civil Code. In August of 2018, the 21st Law Commission released a consultation paper titled Reform of Family Law. In the paper, it stated that the UCC was neither necessary nor desirable at this stage. However, it is suggested that the family laws that are already in place in different religions be revised and written down in order to eliminate discrimination and inequality in personal laws. The Law Commission, which was led by an individual who had previously served as a judge of the Supreme Court, Justice B.S. Chauhan, made the following observation. Cultural diversity cannot be compromised to the extent that our urge for uniformity itself becomes a threat to the territorial integrity of the nation. With this, we come to the conclusion of today's discussion. On the basis of the judgments rendered by the court in aforementioned cases at different intervals of time, it is possible to conclude that the judiciary is in favor of the adoption of a common civil code in order to eliminate differences based on the religious ideologies, prevent the abuse of personal laws, and promote national integration. The government must engage in a process of careful consideration regarding the harmonization of the objectives outlined in Article 51AF and Article 51AE of the Constitution. These provisions pertain to the importance of both valuing and safeguarding the diverse cultural heritage of the nation, as well as renouncing the practices that undermine the dignity of women. A common civil code will help the cause of national integration by removing disparate loyalties to laws that have conflicting ideologies. With this quote of Justice Y.V. Chandrachud, we come to an end of today's lecture. Thank you very much. Have a good day.